In Module 11 we're looking at the protection of individual rights as a way of providing good, transparent and open government. So as opposed to the earlier material that we looked at on judicial review and merits review, which were really about providing a process or providing a remedy, this week we're looking at the situation where we create individual rights that people can protect as an alternative way of doing that. And those concepts, as within most of this course, do dovetail together. They do connect together very nicely. Particularly we're looking this week at the right to privacy and the right to freedom of information, and these are often described as information rights because they're two sides of the same coin. Freedom of information is about accessing public information, and privacy is about protecting private information from the same sort of scrutiny and observation. We'll start with a quick introduction to the concept of rights, and this is something where I think if you study electives in public international law and in human rights, you'll discuss this issue in more detail, but it's something we don't discuss a lot in the program. But there's really two different models to think about when we think about protecting rights. One is the Bill of Rights model, and the most famous of course being the United States Bill of Rights, and that's where you enumerate, list and create a document where rights are overtly protected and overtly written into constitutional documents that can't be changed. In the British tradition, of course, they have what they call an unwritten constitution, which is in some ways more flexible, I guess, but is certainly less certain, where you say British law protects rights traditionally. Where are they? Well, there's the law reports, go look at them, and you'll find them in there somewhere. So there are disadvantages and advantages to both. The US style Bill of Rights approach is definitely more coherent, it's more rational, it's more accessible to people. The disadvantage of that approach, of course, is that some rights are difficult to change as time goes on, and if society changes and those rights are out of step with social change or technological change, you can end up with difficult situations such as providing people with the right to bear arms in an era where muskets are the most dangerous thing, that are now being applied in a situation where extremely dangerous automatic weapons and military grade weapons are now being considered part of that same right. So there is that danger that as things change, it's very difficult to move those rights documents along, and other situations require intervention. So when many of those mini Bill of Rights documents like the US Bill of Rights were drafted, women didn't have rights. Indigenous people didn't have rights. So those things then need to be overtly recognised, and that requires constitutional change, which is difficult, expensive and so on. On the flip side, the British approach, the unwritten constitution, is that we just let the judges be the custodians of rights. And certainly it is theoretically easier to keep up with changes in society than requiring a referendum. But I'm not sure whether that's necessarily true. And certainly I personally have a prejudice towards enumerated and written rights. I don't know, there are dangers and difficulties with rights becoming fossilised and locked in time, but I think as a democratic institution it's important these things be accessible. And I find the British idea of the unwritten constitution, with all due respect to those who argue in favour of it, are fairly preposterous. I find it's very difficult to assert that the person on the street feels certain or protected in their rights when they would require access to a lawyer or a legal qualification and a lot of time to actually find out what those rights are. That situation has come to a head in Britain, although not for too much longer, with the rights recognised by the European Union. And there's a lot of culture clash that goes on. As I said, now Brexit has recently happened. It won't be an issue for too much longer. But in situations where the European Union recognises fundamental rights and recognises them in a way that's overt, and the British system doesn't recognise them, but they have to defer to the European system, at least until they manage to leave the system altogether. Now, what's the situation in Australia? We have a handful of rights under our constitution, which are those that are relevant. I think I've referred to in the notes, and that's about it. There's not very many of them. Freedom of interstate trade, freedom of religion. There's only a small number of rights that the Australian founding fathers were able to agree on, and there was a debate then and has been ever since as to whether we need a Bill of Rights. We have, in the meantime, become signatories to international rights documents such as the Universal Declaration of Human Rights, and particularly the International Covenant on Civil and Political Rights, which are referred to in the notes, which provide, via international law, support for some of those political rights and those administrative law style rights. But international law isn't as easy as petitioning a court in domestic law. International law is a very, very obtuse and difficult creature to actually mobilise, but at least there is some recognition of that. In Victoria, the introduction of a Bill of Rights was done in a very odd way, and there's really no time in this particular course to go through that. But briefly, what they did was attach the concept of rights to the Ombudsman's office, and basically said if people's rights are breached, they don't actually have any right to protect those rights, but they can make a complaint to the Ombudsman, and the Ombudsman can make a report saying, wasn't it terrible those rights weren't observed? And to me that stretches the meaning of what a right is. I think for ordinary people, when you say, I have a right to something, they think it's something that's tangible that they can stand by and say, this is my right and I'll protect it. Saying, this is my right, and that means I can complain to someone who can then make another complaint on my behalf that will, at the end of the day, actually change nothing, I don't think is what everyday people think are rights. And I think it's fairly dangerous for a government to introduce something it calls a Bill of Rights that doesn't function as a Bill of Rights. I think that's quite a dangerous model. But anyway, that's a quick introduction to the concept of rights. Of course, this week we're looking at two information rights in detail that are, while they are recognised under the international rights documents, particularly the ICCPR, the International Covenant on Civil and Political Rights, are only recognised within our system because they're recognised through legislation. And that's quite important, because then there is that question of, are rights inalienable? Which means, can you barter rights away? Can they be changed? And the concept underlying the US model of rights is these things are trumps. Not Donald Trumps, but these are things that at the end of the day you can say, I've heard all the arguments, I've seen both sides of the story, whatever, but ultimately, as unreasonable as I am, in asserting this right, I can always assert it, because at the end of the day, it is a right. And everyone else can say I'm being stupid, everyone else can say I'm being unreasonable, but rights trump everything else. That's not something that's part of our system. And there are pros and cons on that as well. But the dangers where you don't have absolute inalienable rights is you can whittle them away, and you can chip away at them. And you can create a system of legislation, and we've seen this in this course already. Create a system of legislation where you give all the rights and all the benefits in the world, and then over the years, by amending the legislation quietly, surreptitiously, you can chip away and chip away and chip away, and undermine those rights. And that's something that's a real concern, because it's very difficult in the media environment that we have now to get attention to those things that are happening. And people from the Council of Civil Liberties can say there's been another piece of legislation this week and it's chipped away at fundamental rights in these areas. But if there's something more interesting in the media that week, a scandal involving a Kardashian, for instance, it's going to be very hard to get the public attention to that. If it's a matter of competing for attention with some scandal and some celebrity outrage, and all you've got is that fundamental rights to access to review of documents under the military records regime has been changed substantially, so that there's now a longer time period required, such that that right is no longer effective. People are going to turn off pretty quickly. So getting back to the concept of rights again, our approach has been fairly pragmatic, particularly around these information rights. We've set up legislation. One thing we've done, I think, is very good is that we have various information commissioners. There were privacy commissioners and freedom of information commissioners, and in most jurisdictions we've merged those offices together. So at least we have public officials whose job it is to keep an eye on the situation and report on it. But of course those posts are possibly subject to political interference as well, so you always have to be careful about those. But at least that's something. We actually have someone whose role it is to keep an eye on the ball and report back to us over what happens. So we have that, but generally our approach, pragmatic as it is to protect rights through legislation. Better than an unwritten constitution by a long way. But certainly at the end of the day, it means that when the pressure is on, it becomes very easy for government to say, we're suddenly going to exempt this whole area from that particular protection because we've now decided that it's politically too hard, politically too dangerous for us, and we're going to just flip a switch and stop him having access to that right. And that is a particular danger.